All right. Good morning, Eitan. How are you today?
Good morning, Gabe. Doing great. It's a beautiful day here in South Florida.
Excellent. Excellent. Cool. All right. So this video is going to be part of our series on probate. So who this video is geared towards? It's geared towards somebody who has um, had a loved one that unfortunately has passed away, was part owner on a property. And if you're watching this video, then you have an interest in the property and you're trying to figure out, trying to navigate without going and putting down a bunch of money with an attorney. You're trying to figure out, first of all, what your options are. So you have some sort of framework or blueprint to work off of. So there's so much involving probate law. Obviously, not all of that could be summarized in one video. But what we are going to be discussing today is homestead specific. So, Eitan, if you'd start out by just explaining homestead as it relates to homestead property and somebody who's part owner has had a loved one that's passed away. How does the homestead piece relate to the probate process?
Sure. Thanks, Gabe. So, really, Florida is a very unique state in that they have written into the Florida law this homestead provision, and that allows somebody with a primary residence to declare it as their homestead, and it offers certain protections against creditors, and it also determines how that property is split up amongst heirs when that person passes away. So Florida is very unique in that sense. So we can get into a little bit more. But one other thing too is that homestead, people will talk about homestead exemptions, and that is a little bit of a discount that you get on your property taxes for that same property. So it offers a whole bunch of different advantages for somebody for their primary residence.
Okay, so what are some things that, as it relates to that? So you mentioned how let's take, for example, the person that owns is part owner on a property, their loved one's passed away, and they don't want to sell the property. They want to live there. They want to stay in the property, but they want the property to be transferred into their name, right? So, what are the steps required in order to do something like that? What are the things that are going to be considered?
Sure. So first off, I want to make the disclaimer. Neither of us are lawyers, but we've closed over several hundred deals as it relates to buying people's properties in similar circumstances. So I think we have a fair bit of expertise. Typically, when we see homestead property, it'll be in the name of a husband and wife. The easiest cases are when there's a husband and wife, they're both on title. Maybe one of them passes away, then the other spouse inherits the property. That's called, and we can get into that. That's called joint tenants. But anyhow, so that the other spouse will inherit the property. With this marriage, they had kids, and those kids are the only kids that these two homeowners had. So it's not like from a second marriage where they had kids from a first marriage or some other children. So in that, what I call a plain vanilla case, which is pretty typical, there's actually a document that shows how a homestead property is split up amongst the heirs, but typically it's done evenly between all of the children, all of the children of those two homeowners, assuming that both of them were on the deed at some point. And then also, if any of those children have passed away. So let's say in the case of somebody who was 90 years old and then they had adult children, one of those adult children had passed away. Determining whether or not they had children is also important because their children may be entitled to some of the proceeds as well.
Okay, great. I mean, you bring up some really good points. What comes to mind for me now? So let's say, for example, husband and wife live in a property. Unfortunately, one of them passes away, and let's say in this case, it's the the husband. So the wife is living there. So you mentioned, were they married? Yes, they were married. Are things taken into consideration as far as if either one of them owned the property prior to them being married, and if either one of them had children before they were married to the spouse, maybe with somebody else? And was there a will? How would you break those types of things down? And again, obviously, this is not legal advice, but just trying to offer some thoughts and things to consider when someone's in this situation.
Absolutely. Well, the first thing I'll say is that each one of those situations that you just mentioned have caused wrinkles for us in the past when we've tried to purchase properties, where the expectation that's been set by the person who's passed away, as far as, hey, sweetie, you can live here for the rest of your life, don't worry, I got you, you're protected. But maybe they haven't left a will. Maybe they haven't left a will. They have kids from a previous marriage. Maybe they haven't put their spouse on the deed. So even though over pillow talk, they're saying, yeah, I got you, no problem. You have to. It's really important before the person passes away to dot the I's and cross the T's. One of the things that they can do is put their spouse on the deed with them. They can do what's called a life estate. They can put together a will. All of these things will protect the spouse. Unfortunately, if they've done none of those and the spouse is not on the deed, okay, but they're married at the time that the person passes away. Let's say it's a second wife. The husband had owned the property prior to the marriage. The wife's been living there since they've been married, but she's not on the deed. He has kids from a previous marriage, and then there was no will. His kids are entitled to half the property, and she is entitled to proceeds of half the property. Alternatively, if she wants to live there for the rest of her life, she can choose to have what's called a life estate, which gives her the right to live there for the rest of her life, but she cannot sell the property. And when she passes away, the proceeds don't go to her heirs, but they go back to her late husband's heirs.
Yeah. So, there's a lot there, but I think the main thing is that what's coming to mind for me while you're saying that is that these are really things that should be thought about prior to being in the situation where the loved one has passed away.
Yeah.
So if you know of anybody that perhaps hasn't thought about this, perhaps it's you that hasn't thought about this, you might look into this just a little bit, just to determine what exactly is going to happen. We hear time and time again where people say, no, this isn't the way that it's supposed to be. And people are so certain. And unfortunately, when it comes down to the letter of the law, there's a rude awakening sometimes. So ensuring what would you offer information wise for somebody as far as determining whether what their situation is exactly at this point? How would they go about doing that?
Well, I think the first thing is coming up with a family tree. So assuming that the person who passed away has not left a will, then you'd want to create a family tree. And depending on how complicated or simple it is, then whoever you speak to, whether it's a company like ours, whether it's an attorney, that will give the person who's giving you the advice all of the information that they'll need to be able to determine who is entitled to what. And I'll say as well that everybody might be friends when that person's alive. So the second wife might be getting along with the husband's kids from the previous marriage, but when the central figure that connects them all together, when they're gone, the glue that connects them is gone, the claws come out, and everybody wants a piece of the money that they feel is theirs. And so when everything when the relationships are good, when everybody's on good terms, that's the best time to iron these things out ahead of time, and not just have a verbal agreement, but also have it in writing, and doing it with an attorney, so that whether it's a will, whether it's getting the appropriate deed, putting the person on the deed, All of these things are important considerations to do. Otherwise, and we've seen, I mean, we see people right now who we're working with where there's pending litigation where different sides are suing the other side. And what's going to end up happening is that the money that is left is going to be eaten up by the lawyers fighting each other.
Yeah, it's a lot of great stuff there. We'll do a segment at some point on wills specifically. Side note on the will piece, I hear time and time again, yes, we have a will, and it seems like more times than not, the will actually ends up being thrown out by or not acknowledged by the probate attorney, stating that it's an invalid will because of XYZ. So definitely keep that in mind. If anyone has any questions regarding this topic, please feel free to reach out to us. Our contact information is at the below this video here, and we offer a lot of free information as it relates to this, so you can try to navigate this in the most cost-effective way for you. So, all right, thanks a lot, Eitan. We'll talk to you soon, and we'll continue sharing some more information on this in the future.
Absolutely, thanks, Gabe.
All right.